this morning, your oral arguments in the case of the state of Ohio versus Andrew Palmer. Mr. Willis, you'll have 15 minutes in which to present the case. The applicant has waived their argument this morning, so you don't need to reserve any time for rebuttal. So
I understand.
thank you. We are being visually and audibly recorded to be posted online, so please remain behind the podium as much as possible.
Right. What time?
We have read your briefs and we're ready to proceed when you are.
Thank you. If it please the court, I was lamenting the fact that by me hobbling is the result of the failed knee replacement surgery.
Oh, so sorry.
I'm worse off now than I was when I went into the hospital for the replacement. But it's my fault, and because they say I didn't do the rehab right, so I got to go through it again. Not the surgery, the rehab. If it please the court, my name is James Willis. I do represent Andrew Palmer. I really regret to a degree that the prosecutor is not present because there are certain things he said in his brief that I felt he should be required to comment on. But in any event, the facts are simple. The defendant mailed in his own name to a cousin who lived in California in his own name a certain amount of money, which the dog alerted on at the depot for the UPS. No problems. They got a search warrant to search the box that was being mailed to California. It turned out that there was nothing in the box but money. But the prosecutor, the police officers, based on their expertise for reasons that the prosecutor could have explained, he took the box down to the police station, and then with nothing but money in it, he did this in lieu of putting it back in transit and sending it on to California. They went out to the defendant's house and knocked on the door for about 5 minutes, according to the record, and eventually they knew that he was aware of their presence because they could see him. And they did this for about 5 minutes. They came to the door, and eventually, and even the prosecutor sets forth the colloquy that existed between the defendant and the police officers, and one of the things they said was that they need to come in and talk to him. And according to the record here, it appears that he opened the door.
Isn't the state saying that he consented to
allowing that's the issue. That's the first issue. The question is, they knocked on the door for about 5 minutes, which is a clear indication that they want to come in. And one of the cases I cited talked about that this is when they knock on the door for that long a period of time, and the person opens the door, they are opening it in the wake of the insistence of the police officers, and that's not a voluntary act on their part. But nonetheless, as the record shows on page 5 of his brief, he excerpted a segment of the conversation which took place after the judge asked the officer to explain what happened at the doorway. And one of the things the record shows is he said, "I need to come in to talk to you about some things." And according to the evidence, the defendant opened the door, and this officer went in, and another officer went in with him, and the defendant said, "I didn't consent to him coming in." So technically, he did consent, but I'm saying that consent was involuntary. That's my concern about that, and I think that's clear enough. Nonetheless, once in, the officer said that he smelled some marijuana. The defendant said, "I've been smoking," and eventually they sent for a search warrant. After the defendant says they searched the house in advance, and the officer admits, but he said he did that for security purposes. But nonetheless, they got a search warrant. And while they were executing the search warrant, lo and behold, a UPS truck showed up, and it had a box addressed to a person by the name of Greg Palmer, who just happens to be the name of the defendant's brother. The defendant's name was also a G. The evidence was his mother named him after Andy Griffin, and that's why, and the indictment had on it Andrew G. Palmer, and it just so happened that I am jumping way ahead. The package in which the contraband was mailed, again from California, was the name on the package was Greg Palmer. Lo and behold, and this didn't occur to me, it shows you sometimes jurors are smarter than the judges and the police and everybody else involved. One of the questions that came from the jury, inasmuch as the indictment said Andrew G. Palmer, was the defendant's middle name, Greg. And quite surprising to me, I asked him because I didn't know. And he says, no, as a matter of fact, I have with me my Social Security card and my and my birth certificate. And both of them had Andy Griffin, Palmer. So I indicated to the court that under Rule 201, even though the case was on appeal, not appeal, even though the Rule 201 says you can do it on appeal, I think, but even though the jury was in deliberation, the Rule 201, Rules of Evidence, says the court can, in its discretion, take judicial notice. Now, it's very interesting that the prosecutor admitted the authenticity of the Social Security card, which if the defendant had a fake Social Security card, I would like to think it's a federal crime, especially if he's telling the court, he's not telling the court, I'm telling the court, this is a legitimate Social Security card, and this is a legitimate birth certificate, which if it was not valid, I think would be a crime, but I know having a fake Social Security card, it seems to me that was a crime. So the prosecutor conceded that these documents were authentic. So I indicated to the court that I think under Rule 201 that he ought to take judicial notice of this fact and instruct the jury that the defendant's middle name, which was the source of, which was the basis for the question, his middle name was not Greg, and they could have said, you could have answered it that way, or I could have said that his middle name was Griffin, as I indicated, his mother named him after Andy Griffin, Palmer, and he had a brother whose name was, according to him, that's not in the evidence, that's my representation, but he says his brother's name is Greg.
Did you request that he indicate that his brother's name was Greg?
He told me that, but as I said, that's not in the evidence, like, except I told him his middle name is not Greg, his middle name is Griffin, and here's his birth certificate, and here is the Social Security card that has his correct name on it. All the prosecutor says these things are genuine.
The next question is, after he refused to give that instruction, did you object?
Oh, yes, very definitely. I certainly objected. The judge, we had a discussion, which is a part of the transcript, and I made the point. I said, Judge, he is saying that he does not question the authenticity of this document. So why on earth is it, inasmuch as this is the subject, the answer is a response to a question that came from a deliberating jury, why wouldn't we tell the jury what we know to be the truth? It's not his middle name. That's the response to the question submitted by the jury. And I think that the court abuses discretion. I think he was obligated, particularly since the prosecutor wasn't questioning the authenticity of the Social Security card that had Griffin, it had Griffin on it, and he was not questioning the birth certificate, which had that on it. And I must admit, I was surprised. I know I don't carry my Social Security card around. I don't think I've seen it in 30 years. I know the number. No, it's less than 30. I had to have it when I got a passport 25 years ago. But I certainly haven't seen my birth certificate.
I need to ask you a question about that. Regarding your client's Social Security, is that something that came up during evidence, or
No.
did it come out of his pocket when this issue arose?
When this issue came, when the question came up, I asked him, what is your middle initial? What does that stand for? All I ever knew was what was on the indictment, Andrew G. And he said, my middle name is Griffin. As a matter of fact, I have in my wallet, I'm not surprised to me, I have to admit, here is my original social security, and I also have my birth certificate. I said, I don't know anybody to carry their birth certificate and the driver's license around with me, but so be it. It happened that way, and I think it was in his favor, and I think the judge was required under Rule 201, which expressly talks about deliberations and activities taking place subsequent to the close of the case. But apart from that, we then come back. He was acquitted of the things that were found in the house, including the pistol. What was submitted to the jury, well, everything was submitted, but what the jury convicted him of was the package that was delivered to the house. Now, I have to admit, it came from somebody named Palmer in California, but it was addressed to, as I say, Greg Palmer. And the police were on the premises, defendants in custody. And when the package came, they asked him to sign for it. He said, well, that's not my name. I'm not going to sign it. So that's further proof that he never literally had it in his possession because he wouldn't sign for it, even though the police officers asked him to do so. And that's what he's convicted of. That package of 18 pounds or whatever the number is, I really can't recall. Maybe it's 20 pounds. I don't remember what the poundage is, but that's what he was convicted of. Now, they convicted him of that package, which was the UPS package, which arrived while the police were on the premises conducting their search based on the search warrant that they had obtained. So there are two search warrants, actually three. There was a search warrant for the UPS package, which was the money. Turned out to be negative insofar as contraband, but nonetheless the police didn't send it on its way, they kept it. The second search warrant was based on the fact that they went to the house and they asked, after pounding on the door for 5 minutes, we need to come in and talk to you, and he let them in. And then while they're there, maybe an hour later, 2 hours, whatever the time is, up shows UPS with a package to Greg Palmer, and that's what he was convicted
Can
of.
I ask a question on that?
Sure.
The state's brief says that the fact that Palmer refused to allow him to open the box shows that Palmer took ownership of the box. Can you address that?
I think the record is clear. He refused. He was asked to sign for it,
Okay.
and literally he was in custody. That's the key thing. He was in custody.
So that's why they're saying he refused to allow him to open the box because he wouldn't sign for the box.
That's right. He
He
wouldn't.
wouldn't consent to them to open the box because he wouldn't sign for it.
He would not sign for it. That's a part of the evidence. He refused to sign for the box, saying it's not addressed to me. And in any event, he refused to let them sign for the box. And it was at that point they went and got another. That's when they got the third search warrant. They said that search warrant. And I'm not disputing that it had contraband in it. So my position here, one, is that once they interrupted the mail, first-class mail, and we cited cases, and evidence is that they had a search warrant to verify whether or not that odor that the dog hit upon, whether it represented, it indicated that inside that box was some type of contraband. They searched the box. What they found was money, no contraband. And money per se has never been held to be contraband. It has to be something that attends to it.
Mr. Willis, are you sure about that?
Yes.
Aren't there circumstances where money is contraband?
Oh, look, money alone has never been, let's put it that way. Just because I got a whole lot of money, even $1 million, and I cite that case.
Okay, you just clarified it.
Yeah, okay. Yeah, just because I got a lot of money, and I don't tell you where I got it, that doesn't make the money contraband. You need something else if you want to have it declared contraband. You can't indict me because I had $1 million and refuse to tell you where I got it. I cited the Ricardo case in my brief. There was $285,000 found in his house by the FBI. And of course, I'm talking about Anthony Ricardo, so he was the mafioso kingpin in Chicago. So he, in effect, told him, go to hell, don't ask me any questions. If I did anything wrong, lock me up and send it, bring me my lawyer. So they tried to take that money.
Are you not challenging the initial search warrant on the
No, on the money, no. Damn not. They say the dog hit on it, I have no reason to disbelieve that. And that's, according to the cases, the order of State versus Moore, which says if a dog sniffs on the outside of your car, they have a right to open it.
I want to make sure I understood your.
Yeah, no, I'm not disputing that. But what I am disputing is that once they learned there was no contraband in that package of mail, that they were obligated to put it back in transit and send it on its way. They were not supposed to keep it.
Well, what about the officer's testimony that based on his training and experience and the strong odor of marijuana coming from the package, as I believe from the money, that based on his training and experience, he had a reason to believe
I
the
take,
matter should be investigated.
I take with a grain of salt every time I hear that testimony.
Okay, and with that, sir, you're out of time.
Okay, I'm sorry.
Thank you. So thank you for your presentation today. The court will take the matter under advisement and issue a written decision, which